Hi, my name is P.R. Krishnan. Welcome to this fourth edition of RERA My Perspective. In this video, we shall look at all the important definitions. These are important to understand for the purpose of interpretation. We need to be conversant with the definition and what it covers and what it means, as it has implication when we read it with one or other sections. So let us now go to the slide. Okay. Before we discuss the definitions given here, let me add 2 or 3 points more. There's something called CC. It can mean commencement certificate, it can mean completion certificate. So I hope most of you are aware, but still I'll just briefly tell you. Commencement certificate is given only after builder obtains all the necessary approvals. Once he gets all the approvals, then the commencement certificate is given. Only on receipt of the certificate can a builder actually start a project. This is important to know. Similarly, completion certificate is given when the builder completes the project as per plan and layout and sanctioned with all necessary approvals in place and as per specifications laid down. Occupation certificate, this is another one which is basically given after completing, and when it is ready for occupation and all the connections and everything has come in, the BMC comes and checks, and finally if they are satisfied with what one can stay there, then they give the OC. Now let us get into the details of the other definitions. Advertisement, that's what is mentioned here. What does advertisement mean? It means any document described or issued as advertisement. Any document that is described or issued as advertisement. What it means? Any medium. Okay, it could be a notice, it could be a circular, or it could be publicity in any form, maybe audiovisual publicity, paper publicity, or outdoor publicity, any publicity. Informing about a real estate project or offering for sale of a plot. Either a plot or a project, real estate project, they are offering, either it's a building or an apartment that, or inviting persons to purchase in any manner such plot, building or apartment, or to make advances or deposit for such purposes. Clear? So you need to know about this advertisement very clearly, and even all the definitions which you are talking about now. I have not given all definitions, I have just selected a very few 10-15 definitions which are absolutely important. I have selected those only, not any others. So allottee, what does allottee mean? Allottee, how is it defined in RERA? It is in relation to a real estate project. There is a real estate project, it is in relation to that. Means a person to whom a plot or apartment or building, as the case may be, has been allotted, sold, whether leasehold or freehold, or otherwise transferred by the promoter, and includes the person who subsequently acquires said allotment. That means if you have acquired it first and then you sold it to another person, that person also becomes an allottee. So if he has sold to a third person, then that becomes allottee, and to a fourth person he also becomes an allottee. Why? Because the developer is bound by certain obligations to the unit, not to the person. Earlier it was person. अच्छा वो आदमी गया, ये नया आदमी है, मेरे को नहीं मालूम, वो तुम जानो, तुम्हारा पुराना आदमी जानो. That thing doesn't work anymore. So the RERA is very clear. The builder's obligation is with the unit. So today A has come and booked the apartment, he sells it to B, B comes in, then he sells it to C. As long as B is there, builder is obliged to B. As long as C is there, builder is obliged to C. And when A is there, he is obliged to A also. Clear? Apartment. It's a huge list, and whichever way you call it, anything that is covered. There can be a block, a chamber, what you call a dwelling unit, a flat, if it is in a commercial office, showroom, shop, godown premises, or a suite, a tenement made, any other name, means a separate and self-contained part of any immovable property, including one or more rooms or enclosed spaces located on one or more floors. It can be in any floor, it says, or any part thereof in building or on a plot of land used or intended to be used for any commercial or residential purpose. It can be for commercial, it can be for residential, for shop, showroom, or godown, or for carrying on any business operation, occupation, profession or trade, or for any other type of use and solely for the purpose specified. Carpet area. Carpet area is already mentioned here. Usable area of an apartment including covered by internal partition wall but excluding. So what exactly carpet means? The inner periphery of the entire room. Okay. If you are partitioning the kitchen and the living room, that partition is also covered. Partition of kitchen and maybe washrooms, it is covered. Partition of rooms to washrooms, master bedroom, it's all covered. But all within the living area. So within the living area, whatever partitions are there, whatever everything is covered, like walls between the bathrooms and rooms, any rooms, or between kitchen and washroom, or between kitchen and any bedrooms or living room. Those all those partitions are covered. Okay, they have also clarified balcony. Let me just also add a balcony here. Balcony, for the purpose of this clause, the expression means exclusive balcony or veranda area. If you have a separate balcony or veranda area, means the area of a balcony, as a case may be, which is appurtenant to the net usable area. So whatever the internal structure, if it is appurtenant, which is attached to the net usable area of the apartment, which is meant exclusively for you, that should be covered. Clear? So if it has to be appurtenant attached, okay, and it is to be with net usable area, and it is to be used by you separately, so that will be covered. But if there is any open exclusive terrace, open terrace area, those things will not be covered. Okay, that's a common one. But if you are open terrace which is again attached to the appurtenant to the flat, then that will be covered again. Okay, if it is completely only for you and nobody else, terrace area, then that will be covered. Okay, this will also exclude service shaft, balcony, open terraces. Open terrace I just told you. Okay, common area. Common area again is a big definition. It includes all amenities, whether external or internal. All external only. That's amenities, common area. But within the project, okay, and mention the website, whether it includes a staircase or lift or lobbies or terrace parks or any playing ground, playing area, and anything for staff people to live, common basement terraces, park, play, okay, common storage spaces. If somebody is going to stay there, management staff or anybody is going to stay, those areas also will be covered as a common area. Installation of all central services such as electricity, gas, water, sanitation, air conditioning, and incinerating system for water conservation, renewable energy, everything will be covered. Water tanks, sumps, the motors which are occupying some area, that will also be common area. Okay, all community and commercial facilities as provided in the real estate project. Whatever is required for maintenance of the project, everything will be covered under the common area. Now let us move to the next slide. Garage, a critical area for everybody, means a place within a project having a roof, a wall, and on three sides for parking any vehicle, but does not include an undisclosed or uncovered parking space such as open parking areas and open to sky parking. So groundway parking is common area, not a garage. So a garage has to be a three-side parking closed. One side, two side, three side. Okay. Interest. This is one point which we'll be looking at subsequently couple of slides also. This is a very important one because it is defined in different ways at different times. So in different situations I'll be talking on this. Right now, since it's only a basic definition, I'm just telling you how it will work. So in other cases, during the situation, I'll be taking this up. Couple of times it will come. Okay, maybe three times it will come. The definition provided by the Act is the rate of interest chargeable from the allottee by the promoter in case of default shall be equal to the rate which the promoter shall be liable to pay the allottee in case of default. So Very clearly it says if the allot, whatever the promoter charges from you as interest, in case of delay he should also be paying the same interest. It can't be a different one. Earlier it used to be different, but now it cannot be. That's very clear. Going further, they have also clarified how it should be calculated, which should be basically State Bank of India MCLR, marginal cost of lending rate, plus 2%. So that will be applicable on both sides. That has been clearly clarified in one of the subchapters. The interest payable by the promoter to the allotee shall be from the date the promoter received the amount. So it is not from the date of default, from the date he has received the amount. That is compensatory in nature when you come out of the project. But when you change the project, it will be penal in nature. All those things will come later on. It will be penal in nature, and that will be from the date it is in default, not from previous period. So that distinctions are there. We'll see that those later on. Till the amount or any part thereof, till the date of the amount or part thereof, and interest thereon is refunded, and the interest payable to the allotee by the allotee to the promoter shall be from the date of the allotee defaults in payment to the promoter till the date is paid. That means from that date till the actual payment, interest will be coming to you. But similarly, you will have to pay interest from the date you have defaulted in payment. Okay? Promoter. Again, it's again a big listing, I can tell you, but relevant to us in a small way. I'll just tell you. Somebody who constructs or converts existing building for selling, includes his assignees, converts land into projects. That means he takes a land and constructs a building completely, and he sells it without construction. He can sell it with construction. He can sell it without construction also. He can develop the land and sell the this thing FSI, and he can that will also be considered as sale. And if it is a sale, it will come under RERA, where somebody develops and sells both. If one develops, another sells, then both are jointly liable. So that's on that. Broadly speaking, otherwise it's a bit this thing. Even state level cooperative housing finance societies and primary cooperative housing societies which construct apartment or buildings for its members in respect of the allottees of such apartment or building where there is a sale, or any other person who acts himself as a builder, colonizer, contractor, developer, estate developer, or by any other name, or claims to be acting as a holder of the power of attorney from the owner of the land on which the building or apartment is constructed or plot is developed for sale. For the purpose of explanation, where the persons who constructs or converts a building into apartments, one person converts the building into apartments, or develops a plot for sale, and the persons who sell the apartment or plots are different. So constructing is one, selling is one person. Both of them shall be deemed to be promoters and shall be jointly liable for such functions, such responsible for such constructions. Date of possession. Earlier there was no date. Everybody had a problem, or they will give a wrong date. But anyway, even if they give a date, they don't bother. They never used to bother. No more. No more. Now it is mandated to be given in all the agreement. The dates could be different from date of completion, or lesser than given in the RERA website. Agreement date is sacrosanct. Thumb rule is for most projects is 3 years for single structure. A small, medium-sized structure, if the building is made, let's say 15 stories and 3-4 wings, that should be, and let's say 4 wings, 15 or 20 stories, and medium size of amenities should be 3 years max. Not beyond. That's a thumb rule. Even RERA is checking it. So mandatory should be given in all data in all agreements is a data post. Some builders manipulate by stating as far as possible, and then they'll say, I said as far as possible, not possible. It is very clear. There's no term called as far as possible. In fact, in One case, in my case, let me tell you, the builder had mentioned and he lost it. He says they can have the RERA held that they can be no as far as possible. It has been a firm date. They cannot use such excuses to delay. Firm date has to be given in the agreement and that will prevail. There are cases where it has been held even such vague terms to be considered as firm date of possession, and there is nothing like as far as or it is a firm date only. Okay, let's examine the definition of this. What does the definition say? The agreement for sale referred to in subsection 1 shall be in such form as may be prescribed and shall specify the particulars of development of the project, including the construction of the building and apartments along with specification and internal development works and external development works, the dates and the manner by which payment towards the cost of the apartment plot or building is to be handed over, the rates of interest payable by the promoter to the allottee and the allottee to the promoter in case of default, and such other particulars as may be prescribed. Okay, that's it of possession. Date of completion, as I mentioned, this could be a different date from date of possession. Like for instance, you can always say I can put up a tower A on 31/12, let's say 2022, and tower B 31/12 2023, and you can do that, and then this is the project which includes amenities and all, maybe 25. So he can always, he is allowed to do that, right? Okay friends, today in this video we went over some important definitions, right? Let me bring the screen back. Important because we have a good understanding of what these terms mean now, or a better understanding what is all covered. Only then, once we understand this, we shall be able to apply our mind on the act and understand properly. Like under carpet area, what is included, what is excluded, you must know. Similarly, who is an allottee, who is a promoter, it's better to know. This completes this video. So far we have got the background and objectives, the landmark of the new legislation, the main features, and today of course some few important definitions. Okay, in the next video we shall look at very important topic, registration by developer with RERA and interest. These are two very important topics, as you know, and you can look at this in case of issues, and you must know this topic very well. So till the next video I take your leave. If you have liked our video, please do subscribe and press the subscribe button and leave your comments. Also you can share with other groups so they'll also benefit from this knowledge. Thank you so much.